Welcome. I'm Jennifer DeVere Brody, and I'm the faculty director at the Center for Comparative Studies for Race and Ethnicity at Stanford University. Each year, the center selects 3 faculty fellows whose research we seek to honor. Today's Chautauqua honors a new book by Clair, an assistant professor in the Department of Sociology. Professor Clair hails from Nashville, Tennessee, and was trained at Harvard University. In addition to being an affiliate at the Center for Comparative Studies in Race and Ethnicity, he also holds courtesy appointments in many Stanford units, including the Law School, the Ethnography Lab, Urban Studies, and the program in African and African American Studies. This list gives a sense of the reach of his interdisciplinary research epitomized in his book, Privilege and Punishment: How Race and Class Matter in Criminal Court, which came out 3 days ago from Princeton University Press. We will have a link in the chat for a discounted copy. The study follows defendants as they navigate the criminal court process, showing how courts perpetuate race and class injustices. While analyzing the inequities embedded in attorney-client relationships, Clair also provides humanizing ideas, often from the active participants and defendants themselves, for transformation, offering hope for change. We will begin today's event with a short interview and overview from Professor Clair, who will then engage with 2 interlocutors. The first, Professor Subini Annamma from the School of Education, whose own work on the pedagogy of pathologization, an alliterative title of her recent book, intersects with Clair's focus on youth incarceration and justice. Second, we'll speak with Professor Rick Banks, the Reynolds Professor of Law, who also heads Stanford Law School's Racial Justice Center. Please write your questions in the chat at any time. You'll also see postings of full biographies of our participants today there, and also a survey to complete. We will have transcriptions of the event in the final recording, and I apologize that we don't have them live today. In closing, I want to thank our wonderful staff, Drs. Perlita DiCarceo, Dr. Daniel Murray, and Heidi Lopez. This is our final event for the year, and we could not be happier to be honoring Professor Clair's work. I also finally want to note that this is the day of trans remembrance, and that I'm speaking to you from Northern California, and we have a short video around that. Thank you so much, and I'll see you at the end of the interviews for questions. Please write them in the chat.
Stanford sits on the territory of Huichin, the ancestral and unceded lands of the Muwekma Ohlone tribe,
who are the successors of the historic and sovereign Verona Band of Alameda County. This land was, and continues to be, of great importance to Native people.
We recognize that every member of the community has benefited
and continues to benefit from the use and occupation of this land.
Consistent with our values of community and diversity,
we have a responsibility
to
acknowledge and make visible
the university's relationship to Native people.
Well, thanks so much to CCSRE for having me, for organizing this event, for Professor Brody for that wonderful introduction, and for that land acknowledgement. And thanks, of course, to Professor Annamma and Professor Banks for being in conversation with me today. I'm really excited to share my book with everyone who's in attendance. So I wrote this book to understand, give voice to, and hopefully help to improve the lives of people who experience being processed as a defendant in our nation's criminal courts. So over the last 40 years, there's been a rise in the use of various legal techniques and punishments. About 1 million people are arrested each year. More than 2 million people are incarcerated. More than 4 million are on probation or parole. And in addition, state courts process more than 17 million court cases every year. And although these punitive techniques are targeted at the poor, people of color, especially Black and Latino men with low levels of education, more privileged groups have also been pulled into the courts. And the book asks, what is it like to be processed in criminal court today? And how does it vary by race and class? So for over 4 years, I conducted fieldwork in Boston, where I intentionally sought to follow a diverse group of defendants, from an investment consultant and nurses to construction workers and people who are unhoused and unemployed. And I interviewed defendants, prosecutors, public defenders, and judges, and I followed defendants to court and into private conversations with their lawyers. And my theoretical approach and analysis focused on analyzing how the attorney-client relationship is a central feature of the experience of injustice in the courts, given that defendants' primary interactions with the court are often mediated directly through their lawyer. So in chapter 1, I begin by describing people's everyday lives prior to their encounters with courts and their lawyers, and I explain how people from vastly different social positions in my study nevertheless all wound up being arrested and arraigned in court. So nearly everyone in the study, rich and poor alike, experienced profound alienation and hardships in their adolescence. And among the privileged, though, their alienation and their resultant criminalized behaviors were often overlooked by parents, and they were often framed as pleasurable diversions. Whereas the same behaviors among the disadvantaged were often surveilled by police and understood as necessary ways of coping with and dealing with disadvantages in a context of racism and poverty in the Boston area. But at some point, everyone in the study, by design, wound up in court. The reason why I selected people to be in the study was because they had experienced arrest and court processing. And what I found is that their adolescent experiences of alienation and also their continuous experiences of policing have profound implications for their perspectives on the law and on legal authority that they often carried with them into the courtroom, and in different ways between the privileged and the disadvantaged. So chapters 2 through 4 examine how the court process unfolds differently along these race and class lines. So what I found was that for poor Black and Brown defendants, the court process is one where you feel unheard, silenced, coerced, and rarely afforded a chance to share your version of events or contest unjust police abuse in your community, which is often something that people hope they are able to do when they're pulled into the court. Meanwhile, for middle class and white defendants, they often experience stigma and are shocked by the court process. They keep it to themselves. They don't share it with people outside of their immediate family. And it's often unfamiliar to them. But they experience privileges in many ways. They often feel heard by their lawyers, who are often private lawyers that either they hire and pay for, or who they have social ties and connections to. And they're respected by judges and prosecutors who afford them opportunities for rehabilitation, treatment, and second chances because they're perceived to be more compliant. And so by comparing these two groups, I reveal how disadvantaged defendants often have greater knowledge of their legal rights, gleaned from prior experiences with the law, or from vicarious experiences shared in their communities, and they're more actively engaged in trying to fight their court cases. Yet there are lawyers who often feel caught between the power and expectations of prosecutors and judges, coerce them to take pleas, silence them in front of judges, and grow tired of defendants whom they feel and who they personally believe have imprecise knowledge of court norms. And these dynamics have important implications for how sociologists and other scholars understand the basic building blocks of race and class inequality and institutional interactions in American society. So much of what we know about the interactional dynamics of privilege in the United States comes from research on mainstream institutions, such as elite schools or well-resourced schools, doctors' offices. And scholars have shown that middle-class people tend to be assertive, demanding, and knowledgeable in these spaces, whereas disadvantaged people are often portrayed as deferential to authorities and rarely making demands for accommodations. In the courts, however, it's the disadvantaged who have greater knowledge of the law and who seek to make demands by exercising their legal rights. And their relatively worse treatment arises from the different unwritten rules, expectations, and structural constraints that are unique to an unjust court system and broader legal system. And much of this book was inspired by and very much written alongside the Black Lives Movement. So in graduate school, I was motivated to study the courts after marching in the streets following George Zimmerman's acquittal and the murder of Trayvon Martin. And I wondered, what kind of legal system could allow a man to kill a boy out of nothing more than anti-Black fear, while at the same time continually sending young Black men to prison every day for far less. And today, and as you know, after I finished writing the book, we've had the killings of Breonna Taylor, George Floyd, Tony McDade, and so many others. And I see this book as contributing to work around transformation and abolition that's been going on for a very long time. And I see it adding to the abolition movement of police and prisons, an emphasis on understanding and thinking and theorizing through the courts and their fundamental role in perpetuating race and class injustices. And so in the book's conclusion, I reflect on 3 levels of transformation required to bring about justice in the courts, from the level of the attorney-client interaction to the level of society, where I argue that we must rethink the way that we deal with and prevent criminalized social problems and harms. So with that little overview of the book, I'm really excited to be in conversation with both Subini and Rick.
Thank you so much for that overview, Matt. That was really, really useful and really gets us thinking. And your comments about Trayvon and about the idea that somebody can get away with murder just based on anti-Black fear is one that's going to sit with me for a while. As someone who studies criminalization and punishment, but in completely different contexts, schools and youth prisons, the book Privilege and Punishment was so powerful. It's a book where using a unique focus, the experience of being processed in court, and a unique unit of analysis, the relationships between attorney and client, shape and reproduce inequality and injustice. It's a sorely needed intervention into the sociological literature on punishment and speaks to the commitments of the researcher and author, sociologist and Stanford assistant professor Matthew Clair. The 2 contributions of this book are essential for those who hope to understand how crime as a social construct becomes real. The first, that instead of focusing on individuals, recognizing how unequal power relationships between individuals moves us closer to understanding how inequality is reproduced. The second is how interaction styles are not a monolith. Matt, you note that research has found that middle-class people tend to interact in ways that are individualistic and entitled, whereas poor people are often led with deference in many institutions, including education. You go on, the book shows that the divergent interactional styles typically associated with the middle class and the working class and poor are not perfectly transposable across institutions. You query if this is about institutions, education being one where ingenuity is valued, whereas other institutions focus more on punishment and deference, like the child welfare system. I encourage us not to give education so much credit. This is essential to understand because it is less about the style and more about who wields the style. In other words, it is not about which behavior is acceptable. It is about whose behavior is acceptable. It is about who we enable as a society that reproduces inequities and sediments injustice. Another important point in your book I wanted to spend more time with was the ways the experiential knowledge of the legal system that disadvantaged defendants had was ignored by lawyers who relied on their own professional and formal knowledge. What happened was a silencing that disregarded the defendant's type of knowledge from the lawyers, which eventually made the defendants withdraw, while the privileged defendants deferred to their lawyers and were rewarded for that. In your conclusion, you note, access to a lawyer is not itself a form of justice, which was a really radical thought. Tracing the processes of withdrawal and deference illustrated how marginalized people imagined that setting the record straight, sharing their experiences with how injustice and crime are linked could be a form of justice. As someone who works with marginalized incarcerated youth of color, that disregarding of their experiences is constant throughout the legal process, in court, and also into their incarceration as well. When silencing of disadvantaged people of color is recognized as an injustice, both reproducing and causing additional harm, our efforts toward justice can be significantly shifted. So I just want to thank you for all of that I learned from your book. So I want to jump into questions. You know, I'm here to, I just want to talk about this forever, but
yes, please.
At one point, you draw a really clear distinction between inequality and injustice. Can you tell us more about that, what that distinction is and why it was important to make in your work?
Yeah, I guess being a sociologist and sort of being trained as a positive social scientist, if you will, I think often social scientists talk about inequality. They talk about differences between groups, but rarely is there often sort of the next step, which I think is more a moral critique about that difference between groups and what that means and whether it's unfair or not. And so as I was writing the conclusion, the first time I say I wrote that this book probably 3 or 4 times in total. But as I was rewriting the conclusion, maybe near the second or third time, I really came to the conclusion that this is really about injustice. This is me making a critique about the difference between these groups as unfair and as potentially remedied by different social changes and formations. And I think that's my distinction here. And I'm drawing on the work of philosophers, really, Elizabeth Anderson, Tommy Shelby's work. Some sociologists like Eric Olin Wright also have written about the distinction between inequality and injustice. And that's really what I wanted to carry through as I rewrote the rest of the book after writing that in the conclusion, was that I was making a critique about this inequality and I was suggesting that it was unfair and could be changed.
It's really helpful because I think what you're saying is in some work that we're seeing, injustice and inequality are collapsed on top of each other. And in fact, inequality informs injustice. So the more and more inequalities we have, they sediment into injustice.
Right. And, sometimes even, we can think about inequality, we can talk about it, and we can think of it as something that's inherent about the individuals, right, or the group, right? But if we talk about injustice, we're really shedding light and focusing on what is it about the social dynamics that produce those group differences, rather than suggesting that there might be something inherently wrong about the people who are less well off or have less access to material or symbolic resources.
Ooh, say that again. Like that. That's amazing. Okay. So as I mentioned, I work with incarcerated youth, and one of the things that I think we both write about quite a bit is resistance. It's really a shared theme across both of our work. We both honor the resistance, recognizing how sometimes it is effective, but how often it is not, right? But it's still important to write about. So I would love to know a little bit more about why you highlighted the ways defendants resist through withdrawal.
Yeah, so that's actually a really great question. So one thing that was dominant sort of in the literature that I was reading was this assumption that defendants are quite passive and don't do much and don't have much of an impact on the legal process or on their experience of the legal process. And while it's very true that being processed in court is very constraining experience where there's immense social control and much is outside of your control, even of the defense attorney, right? And I write a lot about sort of the feeling that defense attorneys have of being caught between the power of judges and prosecutors and unable to fulfill many of the hopes and expectations of their clients. But when I was thinking about and talking to people, really, I noticed a lot of resistance that's happening backstage and also in open court. And that resistance was more than just them trying to alter a legal outcome and get sort of a better result. It was often more symbolic and symbolically really powerful and important. So especially for disadvantaged defendants who engaged in resistance, so much of the court process was an opportunity to set the record straight. So these are people who, as we know, are living in communities that are constantly surveilled by police. They are constantly facing injustices in their interactions. And it's the court, and the ideal of a court system is that it really brings forth justice. And I show that it doesn't, but that's still the hope that so many people have because we have no other really institution that is ideally set up to do that. And so the resistance among defendants who are disadvantaged, sometimes it's about hoping that they get a better legal outcome, but often resistance would operate in the face of not caring at all what the legal outcome was, as long as they were able to set the record straight about what the police were doing in their community, share that abuse, and articulate sort of differences in how they viewed the alleged criminalized behavior that they were engaged in.
Yes, yes. And it gets back to that idea of silencing, right? When folks are trying to tell what their experiences are, but not just their experiences, how their experiences connect to systemic inequities, right? And then they're being silenced through that in a system that literally names itself the justice system. I can see why this was so important to write about. So thank you for that.
Yeah.
Looks like we have time for one more question. So
Oh no, Nick.
I know, right? We could be doing this for a while yet, but we got to make time for Professor Banks too.
Of course,
he's
of course.
All right. We can but so my question is really, we're in this particular movement, and in some ways the movement, is getting litigated through the public impression, right, of the ideas of defund and abolish the police, right? So we're in this really important moment of thinking about defunding and abolishing the police, and we saw some movement on it, and now it seems like we're seeing some backtracking on it. So I'm wondering, in this narrative, where does your work fit? And what I want to say is, I'm less interested as if you name yourself as an abolitionist, though of course I'm interested in that, but I'm much more interested in how your work can inform our understandings of crime, policing, and the legal system, and how that relates to abolition.
Yeah, so I really think I'm just so inspired by the Black Lives Movement. I'm inspired by conversations about abolition that have been happening since the 60s with the Black Panther Party, with people as far away as in Nordic countries who were talking about prison abolition. Angela Davis's work, Ruth Wilson Gilmore, Dorothy Roberts, and I'm so inspired by the fact that it's really reaching the center of conversations right now in the Black Lives Movement. Just 5 years or so ago, under the Obama administration, really. It was very much about reformist proposals, pattern and practice investigations, things like that, and potentially, doing implicit bias training and things like that with police. And we're finding that, those things aren't going to solve many of the injustices and problems of not just killings of people, but also of rampant abuse that doesn't get recorded, at least not in official statistics, right? It gets recorded in work like the work that we're doing, but not necessarily in administrative data. And so, one, I'm inspired, but two, I think in the book, what I really wanted to do was also insert the place of the criminal court in conversations around police and prison abolition. Really trying to encourage and draw on existing organizing efforts that are already operating around pretrial detention, bail issues, and really expanding that conversation, elevating it, and then also expanding it so that we can have more of a conversation of, okay, as we reduce and engage in partial abolitions and eventual abolition of police and prisons, what are we going to do with the courts? How are we going to deal with the fact that the courts are unjust, that they're propping up police abuse and violence, and that they're the sort of holding way to jails and prisons? And so we really need to think about alternative ways of not just as we reach toward transformation and transformative justice, which leads toward prevention of criminalized social harms and behaviors through investments in housing, education, employment, but also thinking about what do we do when people do harm others? Which is, a fundamental feature of human relationships in society since we evolved on this planet. And so what do we do when people harm others? And I think we do need some adjudicative process. And so I'm really inspired by restorative justice approaches, peacemaking programs that really draw on indigenous methods that have been used and that are still used today in indigenous communities. So there are examples that exist, like in this peacemaking programs that I'm referring to. There's some in New York from the Center of Court Innovation and what they're doing, and the work of others who've been writing about restorative justice for a while. But restorative justice, though, could have problems if it still is tied to an existing carceral apparatus. And so that's important to make sure that we really separate and disentangle those things as we work toward new forms of being able to hold people accountable when they do commit harm.
Right. The restorative justice is one of those things that, of course, was created by indigenous folks and other folks of color and communities of color that practiced it, but then it got taken up into the courts, and that version got taken up into schools. And I'm always interested because we talk about engaging restorative justice, and I keep saying, restoring to what? What are we restoring to, right? We have to actually have a society. We have to argue that there's something that a peace or a calm or a collective sense of justice that we can get back before we can restore it. So I appreciate both the potential of that work, as long as it's committed to that transformative as well. Yes, so thank you so much. I think we're moving on to our your conversation with Professor Banks, but I'm just so glad I got to read this book and be in conversation with you today.
Oh, thank you, Subini. Thank you so much.
Matt, thank you. Thank you for having me as part of this conversation. I am delighted to be here. Matt, this is a fabulous book. It was a joy to read. I mean, it was gripping as well. It was well written. It was thoughtful. It was interesting. There's a lot that I could say positive about it. I'll say some of that, but then I also want to raise some questions about the book. As you mentioned, and this is a bit of a recap, is that you introduced us both to criminal defense lawyers and criminal defendants. You provided really textured portraits of these people. These people come across as flesh and blood people that we can empathize with, we can understand. Sometimes we can even laugh with them, some of the things that happen. One of the interesting things about the project, and this is a great decision you made, I think, is that it's set in the state of Massachusetts. And you would think that Massachusetts, as things go, would be better than many places in the criminal justice system. This was not New York City. It was not Chicago. It wasn't a major metropolis of the sort where we might be less surprised to find problems. So that's part of what made this book counterintuitive, is that it went inside the criminal justice system and found problems in a place where we might expect there to be fewer problems. This book was also counterintuitive in another way. And this is the mark of a good book, that it is counterintuitive, because Matt found precisely the opposite of what I and most other people would expect him to find. As he emphasized mentioned when he first gave his brief overview of the book, you might expect that when we think of criminal defendants interacting in the system, in a bureaucracy, we would expect that the well-educated, affluent people would be assertive and knowledgeable, and that they would speak their minds, and that it would be the disadvantaged people, in contrast, who are more inclined to cower or to be inhibited because they don't understand the system and they're intimidated. But what he found was precisely the opposite. And that's like a mind-blowing thing, to find that the more affluent defendants, typically the white defendants, they're the ones who defer to their lawyers, whereas the more disadvantaged defendants, who are often the people of color, they're the ones who are likely to want to play a more active role in their defense. In part because they've been more involved with the criminal justice system and may in fact know more about how the system works or should work, or about the failings of the police officers in the system. So that's a wonderful counterintuitive hook for the book. And then that was a revelation to me. I would expect that defendants would be most concerned, perhaps only concerned, with their own case and the sort of sentence they're going to receive. And Matt finds that, well, they were concerned about the length of their criminal sentence, but many of the disadvantaged defendants, who are also very much involved with the system even prior to the case, they were concerned about lots of matters that went beyond guilt and innocence. They were concerned about whether officers would be called to account for wrongdoing. They were concerned about the unfairness of the system and being able to call that out. They were concerned, as Matt said earlier, about being heard, or about setting things straight. I'm sorry, he said setting things straight, I believe. So that was very interesting. It was so interesting, in fact, that the book did leave me in particular places wanting more. It's not often I read a book and wish that there had been a lot more discussion of certain issues. But in this book, I did wish that there had been more discussion, in particular of the different types of lawyers involved in these cases. And this was something that you mentioned, but it really struck me that we have three different types of lawyers involved in these cases. First, you have public defenders, then you have private but court-appointed lawyers for indigent people, and then you have conventional private lawyers that are hired by people of means, people who have money to pay a lawyer. So these lawyers are chosen differently and they're paid differently. In the case of the court-appointed lawyers and the public defenders, They're paid, typically I would assume a flat fee or at least a cap fee. They're not paid substantially by the client. So they're not really billing by the hour, and the client has no choice in which lawyer he receives. And in the case of the conventional private lawyer, the client does have a choice of the lawyer, but then the client has to pay for the lawyer, and the lawyer is paid by the hour. So the more the lawyer works, the more the lawyer is paid. That, this distinction between these different types of lawyers, my intuition would be that it would bear on two of the central issues that come up in the book. One of which is a little implicit, I think, but which is there throughout, and that's the potential for a divergence of interest between the lawyers and their clients. In other words, we assume that the lawyer is always furthering the interest of the client, ideally, but of course, lawyers are people too, and they have interests of their own, and their interests might not always perfectly coincide with those of the client. And that potential for divergence might differ, I would suspect, across those different categories of lawyers. The second big issue, which is an explicit issue in the book, is that of trust. What sort of trust does the client have of the lawyer? Does the client believe that the lawyer will do right by the client? Does the client believe the lawyer is really working in his or her best interest? And conversely, how much does the lawyer trust the client? Does the lawyer believe that the client will show up for court? Does the lawyer think the client's going to come back? Does the lawyer think the client's telling the truth? So there are trust issues going both ways. So I guess my first question, I have a few questions. My first question is just to hear your reflection on those two issues. The potential for divergence of interest between the lawyer and the client, and then this question of trust, both the trust of the client for the lawyer and the trust of the lawyer in the client.
Yeah, that's really great analysis and two wonderful questions. So, as you mentioned, there are these three types of lawyers, and then among the indigent sort of defense system lawyers, the two types, the court-appointed who are private, and then the public defenders. About 75% of the caseload of indigent clients in Boston is handled by these private attorneys who are sitting court appointed, and only 25% are handled by public defenders. And so, often when we think about indigent defense, we think, oh, it's about public defenders. But really, actually, most people, at least in Boston, and I think mostly other jurisdictions, lawyers for the poor are private attorneys who are contracted in some way. In Boston, what's unique is that unlike in other places where maybe the payment or compensation for these private attorneys who sit court appointed is by the number of clients served, in Boston it's by the hour worked, which I think helps to deal with some of those disincentives that might be operating in opposite directions between clients and defense attorneys. But at the same time, still there is a sense that if you get a bar advocate, as they're called in Boston, maybe they will be giving a little bit more time to their private clients rather than their public clients. And then there's also often conflation from the defendant's perspective, between the public defender and the bar advocate, because oftentimes you don't really know who you're getting unless you've had this person before and you've had some really in-depth conversation with them about where they're working and you've been to the CPCS public defender office with them. You really might not know whether a person is a private court-appointed lawyer or a public defender. And so you might just randomly then statistically expect then you have a 75% chance of getting a bar advocate, so you have one. And if you don't trust them, that can really, and you trust that their incentives aren't there to defend you rather than their private clients and spend time on you rather than them, then you may be less willing to trust them. And so I think that's one of the incentive issues that might differ between the two types of indigent counsel. On your second point about trust, that is something too that I really wanted to highlight in the book, was this idea that as much as I'm focused on the defendant's perspective and really giving light to their voice, because I think it's missing in the literature, I did want to center on the relational dynamic. It's not just about what defendants are doing. What's operating and happening in the courts is very much a relational interaction that unfolds over time, from the first time you're set up with an attorney and you just meet them, all the way through private meetings, pretrial hearings, to potentially taking a plea or going to trial. And over those periods of times, it's not just defendants who are making sense of lawyers, it's also lawyers who are trying to make sense of clients and determine which clients am I going to spend more time with. who's really paying attention to me and my expertise rather than relying on their own or community-based expertise. And so there is withdrawal that can happen in the disadvantaged relationship, not just from the side of the defendant, but also from the side of lawyers who are withdrawing in many ways from their disadvantaged clients if they feel like they're not deferring to their expertise.
Okay, that was interesting. Let me ask you a couple smaller questions. In most jurisdictions, the court-appointed lawyers, their fees are capped. So they can be paid by the hour up to a cap, which of course might not be enough to vigorously defend the case. Was that the case in Boston, or was it either uncapped, or was the allotted amount ample enough to provide for a good defense?
That's a great question that I do not know the exact answer to. I'd have to look back in my notes to check that. So I don't want to misspeak on that point. But I will say, when I talk to bar advocates, and from the perspective, which I think is really crucial for getting sort of the sense of how this matters for them when they're thinking about their clients. Many times they were very cognizant and aware of the fact, and also in CPCS generally, there's sort of a training level that happens between public defenders or with public defenders and bar advocates together. So when you're first trained as a bar advocate, you're often trained with public defenders at the same time. You don't have the same amount of training. But what's really important in CPCS is there's sort of higher level up that make sure that you're not handling too many indigent cases at any one time. So there is a check to make sure that, even if there isn't a cap, to make sure that you're not able to get in a situation where you have too many clients that on average, we think you wouldn't be able to spend enough time with each client. So from the perspective of bar advocates, they feel like they could possibly give enough time to their clients. But of course, even if they have a certain number of indigent clients, it's unclear how many private clients they may have at any one time.
Right. So that was the second question here I wanted to get to, was that you might imagine that many of the private lawyers are good lawyers, but they're not really specialists typically in criminal defense, or at least they're not required to be specialists in criminal defense. And even if they are, they have other clients who are paying clients. Whereas the public defenders, on the other hand, this is what they've committed themselves to do. They're in an office with other people who've committed themselves to do that. So did you see any systematic differences between the public defenders and the other court-appointed lawyers, the bar advocates, in terms of their diligence, competence, commitment to their clients?
So I will say, I embedded in a public defender's office. So I have a little bit more insight into public defenders, and I also have their insight of their feelings about bar advocates. And so I will say, I think there's a general sense in the defense bar that on average, public defenders are more invested in their clients. They also have more resources. They have access to social workers. They have access to investigators. They're trained in a different way and for longer. And you're right, some of them, went to law school simply because they really wanted to become public defenders. They understand how racial injustice operates generally in American society. Whereas bar advocates are really, they run the range, I think. You can have a really, really great bar advocate, but you can have a really, unfortunately, messy bar advocate who's not paying attention, who comes to court late. And I have some descriptions of that in the book in chapter 4. But I think you could still have a really great bar advocate. And many bar advocates actually were public defenders prior to going into private practice.
Okay, so we have maybe 10 more minutes. Is that right? We'll keep rolling.
Well, we want to make sure that we have time. We have a lot of questions coming in from the audience too. I think we have maybe time for one more question.
Let me get to my big question. Those are the preliminary questions.
All right. Here we go.
I'm sorry, I was saying that we have time for one more question as we want to bring in.
Well, I'm going to get to my question. So let me get to my question. So the big question is what to do about all of this, right?
Yeah.
Which you do address toward the end of the book, right? So the problems you identify, I guess, I just want to, this idea that the disadvantaged clients are not able to get what they want from the system, which is the being heard, to set things right, the healing of some sort. There are lots of things unrelated to sentencing that they want, and they don't get that. And no one gets that, in fact, because that's just not part of the system. So those harms are actually they're not bugs in the system, they're features of the system. That's inherent in the proceduralism, the reliance on professional expertise, the separation of facts and law, which all makes a review possible by a higher court to see if there was a mistake, so forth and so on. So the very problems you identify, they come from parts of the system that are the purpose of the system. So confronted with that, I guess, what would you do, if you were appointed by the governor of Massachusetts as the advisor, right, for criminal justice system reform, right, for the court reform? Would you push wholesale toward a restorative justice system that would, be mandatory restorative justice, no, sort of conventional judicial process, less lawyer-driven, more client-centered, perpetrators and victims coming together to repair the social fabric? Is that what you would push for, or something else?
I think so, but I will say generally, I'm very much sort of, and DA, I think Rachel Rollins at least ran on this in Boston, and that was happening while I was in the field. And this is just the idea that I think we just need to start reducing the number of things that we put into the courts in the first place. Yep. And so I think that's sort of a form of abolition that actually a lot of people can get on board with, even if they don't describe it as abolition, declining to prosecute certain charges, abolishing certain criminal laws, and just making them not criminalizable offenses in the first place. But, with respect to the courts, I think there's a tension in my thinking still, and in thinking in these conversations around, are we seeking to transform these institutions, or are we really seeking to abolish them as they actually exist in the moment? And do we really need to completely rearrange and have a whole new way of doing the court process that we don't even call the court, that we call some peacemaking program or something like that? And, I think there are ways that we can transform the courts right now that are partial abolitions or non-reformist reforms, such as reducing or allowing judges to really feel like they can contest police practices and really question, whether police had probable cause for an arrest, things like that, really encouraging a shift in norms, if you will. But of course, that could only serve to maybe legitimate the system, and maybe that would backfire in many ways. And so I think this is a really hard space, and I grapple with it in the book, and I'm actually grappling with it in another paper right now with a colleague of mine and a great friend who's executive director of the Texas Fair Defense Project, and just actually, her name's Amanda Woog. She just actually helped to lead the way to establish a public defender's office there, for which they didn't have a public defender in Austin for a long time.
It's hard to believe. Ooh.
Yeah, and so so I could go on and on, but that's a quick answer to your great question.
Okay, well, it's a great issue to grapple with. Let's get some questions on the table.
All right.
Great. Thank you both so much, and to Subini as well. So we have fabulous questions from the audience, and I want to thank Veronica Bacchus for getting us started out, was interested in attorney-client relationships, which I think we've discussed, but also in how race and power shape the current legal system. And I want to kind of piggyback that onto a question from David Johnson, who's joining us from the University of Hawaii, who asks about the question of the way in which criminal justice itself is often set up as an adversarial premise with two opposing sides that's supposed to yield sort of truth and justice. And he cites Amy Bach's work, Ordinary Injustice, in this. So maybe to follow up on Rick's last wonderful question on what's the vision looking like and how can we change some of this? What's your opinion on that question?
Yeah, great. So just drawing from, the experiences of the defendants in the study, there's someone named, so they often chose their own name. So he chose Glasses as a name, and his name is Glasses. And he really talked about a time when he was on parole, and there was a stay away order issued from a woman friend of his who he thought he had a wonderful relationship with. And I talk about how he was really saddened by the fact that he couldn't just have this conversation back and forth with her and have some reconciliation about what she believed went wrong and what he believed happened in the relationship. And he felt terrible that really at the end of the day, his best line of defense was to just deny anything happened and to not at all try to make any amends to the person who felt like she was harmed. And then also the fact that the court was very interested, first and foremost, on trying to figure out whether he did something wrong to her as a way to, violate him on parole, more so than figuring out oh, does she need any services? Does she need any help in her life? Is there any way we can make her whole? And so I think that's right. This system is very adversarial. It's set up in a way where defendants have no incentive whatsoever to admit fault outside of taking a really scripted guilty plea. And if we really want to change the way that we reconcile people and lead to restoration, as we've been talking about, we really need to think of a new way to set up this court system.
That's a great suggestion. Thank you. I want to read another question. This is going to take us in a little bit different direction from Jisha Menon, who asks, can you say more about how gender and immigration status, in addition to race and class, has influenced the dynamic of assertion and complete compliance?
Fantastic question. So, immigration status, it's often there are collateral consequences when someone takes a guilty plea or is convicted of a crime that reverberate into their likelihood or potential of being deported. And so that definitely happened in the study where people were concerned and where that conversation came up when the attorney-client relationship was a consensual one and when there was actually a wonderful trusting relationship. When there wasn't, that conversation often did not come up. And that means that there are many things that people may not be aware of as collateral consequences that if they don't have a positive relationship with their attorney, that could harm them in the end, not just the guilty plea itself and whatever comes with the guilty plea. With respect to gender, in the book, there are only I think there are only 11 women in the study of the defendants that I interviewed and also observed, but gender certainly plays a role here. So for white women in particular, and there's a story of Brianna who opens chapter 3, which is the chapter on privileged defendants. I show how her defense attorney often she refers to her as a cute white girl at one point in front of me, explaining to me why she would probably be treated leniently throughout the court process, and also why she enjoyed working with her as a client because it was easier and she could expect to get good things from the legal system. And at the same time, though, gender and race intersect. So there were Black women in the study, and I have a scene where I'm sitting in the gallery with several people who are there either as defendants or as family members. And there were several women, Black women in the gallery next to me. And a lawyer comes in and says, whispers the name of their client, like, so-and-so, are you here? And is just looking around. And basically the lawyer can't differentiate between these different Black women, has no sense of who their client is, who they have already met before, right? And then once she raises her hand, she goes out, talks to her lawyer, she comes back, and then she says to her friend, that was my racist ass lawyer. And that right, is an indication of, the difference that happens between women that is very racialized, but there are privileges among certain women, and then there are disadvantages for other women, particularly Black women.
Let's stay on this topic for a minute because earlier on, one of our audience members asked a little bit about how prosecutors differentiate between advantaged and quote unquote disadvantaged defendants. But Megan Mingo asks if you could talk a little bit more about how you think about the demand the court makes for performing deference. And she says that she's especially interested in the extent to which you might think about it in relation to racial humiliation and degradation and the historical function of the courts in policing. So this is, again, asking to sort of dive in a little bit more on these questions.
Fantastic. Well, first, hi, Megan. Good to see you. Thanks for the question. I think what's happening in the courts is very much racialized. It has been historically. The courts were historically, at the turn of the 20th century, a racist, corrupt institution. Even the differentiation and disentanglement between having a civil court and a criminal court, as recent legal scholarship has shown, was really emergent from an understanding that the criminal court tended to have Black and brown folks and working class folks, whereas civil court tended to be a domain where wealthy, often white people came to adjudicate various legal issues. And so the logics of the court are very much rooted in a racial and class-biased history. And at the same time, I do think, I'm often asked whether sort of the agency and the resistance and the response from prosecutors, defense attorneys, and judges of silencing and coercion is because of the acts itself or because of the people who typically are doing those actions. And I think it's both and. I don't think it's either or. I think that these actions are often very much racialized and that they often are worse when they are engaged in by people who are racialized as Black and Latino. And even what even is characterized as resistance, right, in the first place is very much racialized. So very much throughout the court process and in these attorney-client relationships, the dimensions of disadvantage have a racial history and present.
Great, thank you. We have just a few more minutes. I don't know if we want to bring back on our original interlocutors. Subini and Rick maybe come on, and if there's any other questions from the audience, I think it would be interesting. Maybe we didn't talk as much today about methodology, but can you maybe speak to that just for a moment in terms of the use of the interviews that you conducted?
Yeah, sure. Sure. When I first started the project, I was conducting interviews mostly, and then a few clients invited me to join them, and also my dissertation chairs suggested that maybe I might want to follow people through court, and so I started following them. And then after a while, I went back into the field. After a while of taking a break and writing my dissertation, I went back in the field and I did even more data collection, where I embedded in a public defender's office. And followed 3 public defenders, a Latino woman, a Black woman, and a white man, as they interacted with their various clients. And so I got to observe private attorney-client interactions behind closed doors and in public open court settings. And that was really useful because I not only got those 2 sort of dimensions of data, but I also got to talk to them privately without their defense attorney. And so I got to see, how they operated in open court in front of judges, how they how frustrations and private conversations occurred behind closed doors, and then many of the things going on in defendants' lives that they don't share with their attorneys, that they hide or obscure from their attorneys, I got access to, and then also just their real, true feelings about their attorneys, that I also got access to. So that's a little bit about the method.
Great, thank you. Well, I think we're almost at time. Is there any other questions that either Rick, Subini want to ask?
I had one more question, Matt, that I'd love you to wrap up with. Rick pointed out, and Rick, this was helpful for me as somebody who's not in the legal system, but studies criminalization in other places, right? It was really interesting for me to hear you say, these aren't accidents, these are features of the system, right? This is the way the system is supposed to work. It's supposed to silence people. That's the way the procedures are supposed to work. And so, Matt, when you think about the fact that the marginalized or what you call the disadvantaged defendants wanted redress, not only for individual discrimination, but also for structural injustice, whereas the privileged simply wanted to avoid harsher punishment, what do you think that says about our legal system, that people have such different wants? And how do you feel about the idea that these harms are just part of the system, as Rick said?
Yeah, I think that's a great point. And I think that speaks to the fundamental part of the book about privilege and punishment. And so much of the privilege of middle class and white people in their interaction with the system is that it's just so rare. It's rare that they're pulled into the system, right? And so really when they're pulled into the system, they've often actually done something wrong. And they're actually ready and willing in many ways to admit that they've been doing something wrong for a period of time and just haven't gotten caught, as I talk about in chapter 1. And so I think what this speaks to is really a fundamental aspect of how our legal system, the punitive aspects of it, have grown immensely large, especially in poor and working class communities of color. And it's just far too routine and unfairly applied in these communities in a way that it's not in privileged communities, where in chapter 1 I talk about, honestly, similar criminalizable behaviors are going on in these communities, but people aren't being pulled in and to the punitive court process. They're instead getting treatment, rehabilitation, help. And so when we think about things like abolition, we should recognize that actually, if we look at privileged communities, abolition really is already occurring in many ways for them.
I think that's a great way to conclude and see show us what we have to do before us. And I hope everyone reads the book and enjoys it and learns more about what we can do to really create, thank you, Subini, justice and fight injustices in the system. Thank you so much, Professor Clair, Professor Annamma, Professor Banks. Thank you both for showing that and for your wonderful, wonderful work that is really, I hope, going to transform so many things. Thank you all for joining us.